Brad, who has been a long-term member of this panel, has therefore prepared a few words. I'm going to cover some issues which struck him as being common pitfalls, and we'll have a few solutions. You may have noticed just as we got going, Rupert said a few words to me. They included finish on time. We will make every effort to finish at 12:45. So, Brad, over to you. I'm not offering you the whole time.
Thank you. Just a brief introduction from CTAC in Hong Kong. So it's established in 2012. We came there because we see an increasing Chinese parties going overseas to make deals with the world. So CTAC have decided to have an overseas arbitration institution, makes it completely neutral, based in Hong Kong, using Hong Kong law to govern the case, to administer the cases. And this morning I just saw this living proof of how CTAC should have a Hong Kong institution to resolve disputes across the border. This has nothing to do with dispute. This is a sale open advertisement. It's from Redmi 4A. It's a Xiaomi cell phone, which a lot of Chinese they like to use, and it starts this noon. So and it's on top of the Times of India newspaper. So you can see the trade and communication in China and India getting increased. And going back to the topic, I was instructed to tell some pitfalls of arbitration that CTAC Hong Kong to witness. So I did some homework before I came to New Delhi, and what I did was search the hk@ctac.org, that email address, and I typed the keyword India into it and tried to find all the inquiries that we received. And man, there was a lot, and a lot of, I think it ranked #1 when it comes to inquiries. It's not #1 when it comes to caseload, but #1 in inquiries. And it forms a pattern. The pattern is, now we have this, we made a deal with the Chinese company, maybe at the Chinese fair or exhibition, and the contract is concluded, and several months later, we have a dispute. Probably it's about defect of, it's about the last installment, and now we want CTAC Hong Kong to help us to arbitrate. Now the problems we have is that we usually will examine the contract that they made with the Chinese exhibitors or the Chinese companies or factories. The problem is there's nothing in there when it comes to dispute resolution. There's no mentioning of that, and therefore we can do nothing, basically. We can do nothing about that. We're usually referred the Indian companies usually are referred by Hong Kong TDC or CCPIT, which are both like trade unions and handling the dispute between China and elsewhere in the world. Now the problem is there's nothing we can do to start an arbitration. So anything that's about managing arbitration processes, we can't even go there because there's no arbitration to start with. So next time, and a lot of emails, they're written by in-house counsels actually, when you think about any potential dispute resolution, think about it beforehand. It's like, we get this metaphor a lot. It's like arbitration institution. A lot of parties, when they think of that, they think of arbitration institution as a fire station. It means that unless there's a fire happening, they won't think of them. It's like fire station. When there's a fire, you call the number, and firefighters, they come. But that won't happen for arbitration. You need to have arbitration agreement. That's the first pitfall. You have that. And it doesn't really matter. We have NPAC here, IDAC here, and there's no other reason that I wouldn't think of. Well, if I'm an Indian company, I should start with that if it comes to arbitration. But if negotiation goes out elsewhere, probably HKIAC, CTAC Hong Kong, ICC, whichever you choose, whichever you're comfortable with. But think about the advantages each institution has. For example, language. Even for us, CTAC, a lot of parties, when they actually agree to arbitrate as CTAC, they want to arbitrate as CTAC Hong Kong when disputes actually arises. Several reasons. One is about language, because they are more comfortable using English rather than Mandarin. They are more comfortable with not translating every piece of document from English to Chinese. Actually, that would cost parties a lot. And the other reason would be probably communication is easier, and the governing law you're more familiar with. So that's before the arbitration procedure. The second pitfall I like to pick out is during arbitration process. It's about appointing arbitrators. I'm from China, so I like to observe Chinese parties' pattern when it comes to appointing arbitrators, and I find two. One is that they have this tendency to appoint an arbitrator that is so famous, that is so well known to everyone, and the second pattern is that he would like to choose a friend of his. I can't really make judgment on that, but I invite you to think about it. Take me and Bruce, for example. Maybe in some cities in mainland China, I dare to say that I'm more famous than Bruce. So some friends or some practitioners, they appoint me for an arbitration, maybe English law to apply. Maybe the key issue of law in that case is about, I don't know, I don't even make that term, exemptions, for example, or exemption clauses of English law. How would I make the same contribution that Bruce would have if he was appointed, even for that Chinese company in an international arbitration where you English law to apply? Same with Ravi, for example. If the arbitration is seated in India and I was appointed because I'm a friend of that Chinese party, how would I make the same contribution when everything I can talk about Indian arbitration is that, oh, I've heard there's an amendment of arbitration law in India and there are a lot great improvement on that. That's what I can contribute. How can I replace the importance that Ravi get to have for this case? So that's just an example, because usually when parties, I'm spending too much time, so to limit the pitfalls that I encounter during arbitration process, I think one of the most is about appointing arbitrators. Appoint one that is really appreciate your case and make a contribution in the tribunal at every stage of arbitration. The third pitfall is usually I think parties are less and less appreciating the contribution that mediation and settlement can have. That happens for CTAC as well, because we see the trend of mediation is decreasing. At the past, it's about 30%. Nowadays, it's 10%. But it can be very effective. And a surprising factor here, a result here is actually the majority of mediation cases happening in the process of arbitration at CTAC. Those cases, those mediation processes are actually initiated by international parties, not the mainland parties themselves. And at the end of the day, they live with that decision that they made with the other party. For CTAC Hong Kong, for example, we usually call it China-style mediation, but there's a case I can still quite distinctly remember which happened last year. The presiding arbitrator was actually from Singapore, and he conducted what would normally be seen as a quite typical Chinese mediation, and that case got settled. And what we did is that we suspend the arbitration. It's like a timing order if you're from common law jurisdiction. We suspend the procedure, let the parties to voluntarily enforce it, and we make a timetable for that. If timetable was not strictly followed by parties, we would resume the case. We never resumed the case, so it was quite successful. And that's my time. Sorry, I'm taking too much time. Sorry for your lunchtime.
No, not at all. Thank you very much, Brad, for setting the scene. Aditya, since you have both institutional experience and more recently experience as counsel, can you enlarge upon the second point made by Brad, which is relating to unsuitable arbitrators? He identified two areas of concern. I noted bias. You might be more gentle and suggest it's predisposition to a certain point of view. And then secondly, competency. Have you got any views on what you've seen both as an institution and what you've seen in the last 4 months or so?
And that's very important, because you ultimately want to, when you to ensure that you appoint competent arbitrators, you want to appoint independent and impartial arbitrators. from my experience at having worked at HKIC, the key consideration for the institution when appointing an arbitrator is to ensure that the arbitrator that is appointed is independent and impartial from the parties. So even if you as a party nominate your arbitrator, the institution doesn't confirm that arbitrator until a conflict check is undertaken. That arbitrator has to declare his independence and impartiality. That arbitrator has to follow the IBA guidelines.
In alternative dispute resolution techniques, or whether there's a general knowledge or ignorance around those techniques. Ganesh, have you got any observations to make? Ganesh, Quar arbitrator.
As per ancestral model as well as our Act has a provision section 30 regarding settlement, where arbitrator can, if there is a possibility of settlement, then what I find here is by the time matters okay, that is fine, it comes. And also the Indian law has been enacted, civil CPC has been amended, and as per section 89 also, even if a matter goes to court, if there is an element of settlement, it can be referred to various ADR processes, including arbitration. But in fact, when matter comes to arbitration, most of the cases, there is a prolonged pre-arbitral process. Some of them are departmental officers, or sometimes a DRB, DAB. The experience in India has been that we don't have a statutory adjudication like Construction and Regeneration Act in UK and similar laws in Singapore, Australia, Malaysia and other countries. So we have nothing like an interim statutorily binding decisions. So the contractual mechanisms like DRB, DAB or any other methods have not been found effective, because even if these are right, these are not implemented. And ultimately everything comes to arbitration. So actually when it comes to arbitration at that stage, when all these methods have gone, whether there is a possibility of settlement, I have personally experienced settlements only happens when certain admitted amounts of final bill, etc., which are not crystallized and now crystallized, and parties say now we settle this. So these are not really disputed questions, other things don't come in. The second problem is coming now. What happens if we are going into settlement process and the arbitration process is kept under abeyance? So there is, again, if this process, there is no system to account for this process. So theoretically I find it, but and if at all, as in India, most of the cases are with one of the public authorities, I have personally found the settlement things are really very difficult. So it is better to resolve it through arbitration and so that it is finally implemented.
Thank you for that. So Ravi, turning to you as counsel, what is your view in relation to what happens to the process, bearing in mind these tight time frames set under the new legislation, 12 months plus 6 months, if the arbitrator decides to move into an ARB-led procedure, what happens?
See, even though there is no strike provision to say that settlement can be extended because of parties opting for ADR or some other alternate dispute resolution methods like mediation or ADR, whatever it is. But always when you go for an extension, you will look into the reasons why this process got delayed. And they can apply the situation in hand and take a decision to extend the time. It is not that courts will not apply this and they will take a wrong view. Always when there is a bona fide reason, when there are reasons to state that there was a effective alternate resolution process was in progress and there was no time was wasted by either the parties or the arbitrator, then definitely courts will extend the time. That should not be any. That's what I feel.
Thank you. One area of concern, becoming possibly of great concern more recently, is the delay in the arbitration process around the delivery of the award. And that may be, and I think this segues neatly about appointing the right arbitrators, because some arbitrators are so busy that it's hard to get to schedule hearings. It's hard, even once you've had the scheduled hearing, to get an award out of them. What are the remedies? we're confronted with that. People take on too much work. What can the institutions do to deal with that mischief, which is, to put it pejoratively, greedy arbitrators?
For CTAC, actually, we're known for have a speedy arbitration because for CTAC headquarters, for example, usually the median time for rendering an award after the composition of tribunal is within months. It's 3 to 4 months actually. So for CTAC Hong Kong, it's 115 days in 2015. But recently we have been receiving complaints. We're being very honest here. I took up my time, very honest. And the thing is, no offense, sorry. It's just, well, it went backfire like this. I didn't expect that. Okay, but the thing is, that we do receive a lot of complaints about recent cases being delayed and delayed. Sometimes it's parties their own fault. That's for sure, because they just, like Bruce earlier mentioned, an ICC case, similar situation can happen at CTAC Hong Kong, which is thoroughly joined.
Brad, to interrupt, it cannot be the party's fault if the hearing is finished and the delay is simply the passage of time from finalising the hearing to delivery of the award. How can you accelerate that process? Parties
may still submit written submissions saying we understand the hearing is closed, but we still think this is important for the tribunal to understand that we have this and we have that and we have that. And sometimes they extend for further time. And that is what I'm blaming the other parts at my second. So parties for that's one. The second is sometimes it's even for ourselves. We are for CTAC, we are overloaded with cases. Some case managers are very busy. They don't push arbitrators as often and as they should. So sometimes we ourselves have problems on that. And sometimes arbitrators, yes, you need to get upon the right arbitrators. One time I heard an excuse from an arbitrator who said that, sorry, I'm on a cruise, so I need to get back to you within 1 week if the email service doesn't go very well in the ocean. So that's that. All of those. For CTAC, we're trying really hard. We have a new chair, vice chairman for CTAC, who is very, very concerned about the time limitation, and he's pushing everyone to the limit when it comes to have an efficient arbitral award coming out of CTAC and CTAC Hong Kong.
Thanks, Brad. So, Aditya, how does the HKIAC crack the whip?
So HKIAC has made efforts to make the process more transparent. So where HKIAC has had experiences with arbitrators who've taken excessively long to render awards, have removed them from the panel. And that sanction effectively then takes away that amount of revenue from arbitrators. Arbitrators know that if they do not render awards within a reasonable amount of time, they will then face disciplinary action by the institution by being removed from the panel and list of arbitrators. That then takes them away from appointments. Recently, we had a case where a very well-known arbitrator, where HKIAC received a party nomination, a well-known arbitrator in Hong Kong. And unfortunately, because institutional arbitrations are confidential, parties don't have information as to the track record of these arbitrators. It's only institutions who can see them from within. And this particular arbitrator had taken a year and a half after the proceedings closed to render the award. He was being chased every month, and it was complete wanton disregard to the process. And obviously disciplinary action was taken. He was removed from the panel, but the parties, as I said, do not know what had happened. So in a different arbitration, he was nominated. And as I said, if you as a party nominate an arbitrator, he has to be confirmed by the institution before he gets the appointment. So that particular arbitrator was then asked by HKIAC to disclose to the parties how much time he's taken before to render an award. And after that information was then transmitted by the institution to the parties then said, look, we withdraw our nomination of that arbitrator, we want somebody else. So institutions like the HKIAC, even the ICC, for instance, before they appoint an arbitrator, they will ask the arbitrator to disclose the number of appointments he's received this is so institutions have a sense of what the availability of that arbitrator is before appointing that arbitrator. HKIC has recently undertaken to amend its declaration form to ask that arbitrator to stipulate how many appointments he has, how many pending arbitrations he has, and that gives the institution a sense of how available is this arbitrator, is he going to dedicate the time to the matter or not. But the back end, the interest here is, look, they want to appoint someone who will give you your time and money.
Thank you. So Ravi, from the perspective of counsel, what do you do when an arbitrator is not, or tribunal is not delivering in a timely fashion?
So in one of our ICC arbitrations, we had such a problem of eight months, not the 16 months looks very unusual, but 8 months delay was there. Then we had to literally make compliance to the court, people, ICC court people sitting here. They followed it up. And unfortunately, that award was also got set aside, was not enforced. The award was also not given in a proper way. So there were some technical difficulties, so the award was not enforced. That too, a court in Singapore refused to enforce that award. So that was a very bad experience for us. I always think that somehow the leading arbitral institutions should start developing a kind of database so that they are able to exchange among ourselves. See, there is a banker's data exchange. If I don't repay to one bank, the other bank also knows. Likewise, at least the leading arbitral institutions should be very careful and in exchanging these kind of data, which will really help the arbitration process go well. The other thing is party-nominated arbitrators is another issue, over which many of the institutions do not put a real check because they may not have the sufficient data about those people. The party nomination is different, party appointment is different. No international institution allows an appointment. It is only a nomination. The institution has the absolute right to say no also. But many of the times that is not exercised by the institutions. Because it is really necessary, large amount of money is spent in the progress of the arbitration, in lawyers' fees and all, and then we don't get the award in time is a real pathetic condition. For that, all the arbitral institutions should find out a mechanism and platform.
Thank you. And Ganesh, finally, you're not a greedy arbitrator, but when you sit on a panel where you have a greedy arbitrator who's just not available, slowing the process down, particularly if perhaps you're the chair, what can you do? The respondent's arbitrator, he's got 15 references running and he's never available. What can you do to make the process move forward?
The arbitrator is not available?
Mm-hmm.
Yeah. See, right now we have a remedy. Yeah.
Why the award?
Yeah, for making the award. For making the award, I think, except that delay after writing the award, except parties requesting, I think nothing more can be done legally. And there are cases in India, in one case, Delhi High Court set aside an award, which was placed much after the conclusion of the case. But that is when the party approached the court, finally. Otherwise, legally, I do not think there is. Mostly in India, it is an ad hoc arbitration. If it is an institution, we can approach the institution. If it is not an institution, other than requesting the arbitrator, I had some people ask me, there are cases where others are arbitrators. Again, sorry to say, again, a retired Supreme Court judge. But then he asked that, what should I do? I find that I accept requesting him, nothing can be done at this stage. And at the worst, the court, where also there is no specific provision. But it has been, the amendment has been now, it has addressed this issue. But right now, because now we have to give a disclosure before appointment, how many cases I have got, and I have to also give a disclosure, that arbitrator has to give a disclosure that I will publish the award within 12 months. So this has been taken care of by legislative action now. But the previous cases existing which are going on, I do not find any remedy except pursuing the arbitrator and requesting him.
Thank you. Well, we've hit our time. So, first of all, may I thank the panellists for their industry and in particular Brad for putting together a little bit of a